All right, welcome everyone. This is the panel on legal needs surveys. My name is Matthew Burnett. I am the Senior Program Officer for the Access to Justice Research Initiative at the American Bar Foundation. This panel is going to require us to say words like justiciable today, so I hope that you will give us a little bit of leeway on stumbling over some of the technical terms. I'm really delighted to chair this panel on legal needs surveys and with such an exceptional group of panelists. We have two folks who are remoting in virtually today. They're going to go at the end. But before we get started, I did want to do introductions, and I'm going to introduce folks in the order that they'll present. So you'll have a sense of the order. So our first speaker today is going to be Daniela Barba, who is the Director of Research in Access to Justice at the World Justice Project, where she's led and engaged in research on topics including disparities in access to justice and the political economy of justice reform using quantitative and qualitative methods. She has an academic background in political science and social policy and has worked for the Mexican government and nonprofits in Mexico and the United States. Next will be myself. As I said, I'm the Senior Program Officer for the Access to Justice Research Initiative at the ABA or ABF, an independent institution from the ABA. I'm also a visiting scholar at Arizona State University with Rebecca Sandifer and an adjunct professor of law at Georgetown University. Natasha Brown is Director of Access to Justice and Community Engagement in the University of Manitoba Faculty of Law. She leads access to justice initiatives and coordinates work among Manitoba stakeholders. She was previously the Director of Professional Practice and Externships and the Legal Director of the Legal Help Center of Winnipeg, a legal clinic in downtown Winnipeg. And she's currently teaches a course on access to justice. Meredith Brown is partner at Calibrate, a consulting firm that focuses on access to justice and justice system transformation. She works in Ontario, across Canada, as well as globally for a wide array of clients, from Indigenous justice organizations to the UN to the Law Foundation of Ontario, which is what she's going to talk about today. And then remotely, we have Heather Heavin, who's an associate professor and associate academic dean at the University of Saskatchewan College of Law. Heather is a member of the Create Justice Research Center at the University of Saskatchewan, the executive committee member of the Center for Forensic and Behavioral Science and Justice Studies, and a member of the Saskatchewan Provincial Access to Justice Network. That will be the most times I've said Saskatchewan. Heather's main research interests have been in creating and applying frameworks to better understand and assessing risk in legal matters. And more recently, she's co-leading a project on competency-based legal education. She and her colleague, Bray Lowenberger, who I believe is in the audience, have worked on a number of access to justice research initiatives, including the legal needs assessment for Saskatchewan and legal data in Saskatchewan, released in 2023. And finally, Luis Guevara is research focused on applied behavioral science in both public and private sectors with an emphasis on access to justice and problem solving. As part of the National Planning Department in Colombia, he led the design and analysis of both the 2020 and 2022 legal needs surveys. So with that, I'll turn things over to Daniela.
Thank you so much. So thank you, Matthew. Good morning, everyone. So just for some context, the World Justice Project is an independent, multidisciplinary organization that creates knowledge, builds awareness, and steers action to advance the rule of law and access to justice worldwide. A couple of the country level and global figures that you heard yesterday from Chief Justice Tolok are actually from the World Justice Project, and the Rule of Law Index 2024 edition was actually released yesterday. So I invite you to check that online. But the preliminary findings that I will share with you today are part of a project that seeks to develop guiding tools for decision makers wishing to advance justice reform centered around people. This project is partially funded by the World Bank and the Korean Legal Trust Fund, and I have worked on it with my colleagues Alejandro Ponce and Grace Holzman. Here. Okay. So we know that access to justice worldwide faces various overlapping challenges. Following a jointly designed methodology in 2019, the WJP estimated that 1.4 billion people worldwide are in the justice gap because of their unmet civil and administrative justice needs. Yet, as it has surfaced in many of the panels here, the resources available for justice are scarce. And when justice reform does occur, it still tends to privilege institutional needs such as efficiency over people's needs. So the goal in the back of our minds while conducting this research was to test possible ways to use WJP's data to target justice reforms or solutions around people's justice needs that are relatively more significant. It's an effort to contribute with approaches to conducting legal needs assessment pre-intervention. Specifically, we sought to find out what barriers to critical justice services pose the greatest obstacles the greatest obstacle to solving people's legal needs or legal problems. We know from legal needs surveys research that only a few people experiencing legal problems go to courts and lawyers. But here we ask where people get lost in their justice journeys or where the highest pain points are in people's journeys towards justice. So we start from the assumption that different kinds of legal problems occur under specific power dynamics and asymmetries, disproportionately affect specific groups of people, and involve a particular combination of justice services. And given their frequency and implications for people's lives, we focus on family legal problems in this research. In a report that we released last year based on our legal needs survey, the Global Legal Needs Survey, we found that also family legal problems affect disproportionately women and people living in poverty in a majority of countries. So following the justice journeys tradition, we start with an analytical reconstruction of people's pathways to justice to explore the degree to which barriers to crucial legal services affect people's solutions to family legal problems. We are able to assess with our data the influence of barriers to information, assistance and representation, and dispute resolution mechanisms, not necessarily post-resolution services. We also take into account confounding variables to be able to compare apples to apples, but I'm not going to get into that. And in terms of the methodology, we conduct a statistical regression analysis of legal needs survey data. And for this, we leverage the legal needs surveys conducted by the WJP in 104 countries with more than 100,000 households over the last 7 years. And we also consulted with experts in family law from 11 countries and conducted an extensive literature review. So turning to our preliminary findings, this flowchart shows the predicted chance of solving non-trivial family legal problems depending on people's access to different justice services. So on average, not taking into account access or lack of access to justice services, 6 out of 10 people with non-trivial family legal problems report that they solved their justice problem independently of the resolution. So there was a resolution and the problem does not persist. But unsurprisingly, when people have access to different justice services, including access to information, access to assistance and representation, and dispute resolution mechanisms, 7 out of 10, if you see the last column, the first bubble, 7 out of 10 are able to solve their problem. When they face barriers to these services, only 4 out of 10. But when we look individually at the effect, or to what degree there's an influence, not an effect, but an influence on the solution of legal problems by individual justice services, we find that when looking at the influence of individual services, the chance of problem resolution was 21% lower for people who encounter a barrier to good information and advice. So this is the largest pain point in people's justice journey, or to family justice journey. We find consistent results when holding constant socioeconomic characteristics, or as I said, to compare apples to apples, individual socioeconomic characteristics and also country level, the severity of legal problems, or looking at problems that do not require access to a dispute resolution mechanism. Beyond the global average, we find that facing barriers to information and advice is a larger pain point in countries with high and medium levels of gender inequality, according to the United Nations Development Program. And relevantly, looking at the combined effect of different services, so running interactions, we find that access to information significantly potentializes the effectiveness of accessing a dispute resolution mechanism, which is probably not surprising here, but we kind of provide the evidence from these legal needs surveys. And this has implications for the commitment of conventional justice actors to early intervention services. So if we look at other kinds of legal problems, we find that barriers to information and advice are also significant pain points to the solution of these of money and debt-related legal problems, land and property legal problems with public services, as well as for family legal problems, not as much for employment services. And of course, these findings can be tested through more context-specific assessments and consultations, as we discussed yesterday. This is particularly true of the service characteristics, meaning their timeliness, how integrated or linked they are to refer us another OECD people-centered justice criteria. How these characteristics would result in good information and legal capability. This is an area of our interest, and we hope that with the analysis presented here, we contribute at least to advancing the conversation around legal needs assessment to guide justice solutions and reform. So once again, thank you so much, and I look forward to your comments and recommendations.
So I'm going to ask Daniela to keep me accountable. Okay. That's how justice works. Right?
Sounds good.
So today I want to talk a little bit about some work that we're doing around understanding the nexus between civil and criminal justice problem experience. This stems from an award by the Bureau of Justice Statistics in the United States, which for the first time is considering designing and testing official government statistical civil legal needs survey, which is a little surprising that in the United States we have never had any official survey data on civil legal needs. There are a couple of characteristics of this that I think are interesting. One is why this doesn't happen more often. And one part of that is just the same problem that we're seeing in the US, which is that the Criminal Statistical Agency and folks doing civil statistics aren't always aligned, or they're siloed in different ways. But in others, I think that we oftentimes think in our own silos about civil justice problems. We address civil legal needs as a legal service provider, and public defenders and others deal with criminal legal needs. And so we need to start kind of de-siloing our understanding of these experiences. The goal of the program, which is in partnership with NORC at the University of Chicago, is to identify and fill gaps in statistical coverage of access to justice for civil legal needs that will inform an understanding of the intersection between criminal justice system and civil justice system. And an interesting feature of this is that by statute, actually, the Bureau of Justice Statistics requires that civil justice research bear directly on and substantially upon criminal justice matters, or be inextricably intertwined with criminal justice matters. And that comes from Section 818 of the Omnibus Crime Control and Safe Streets Act. So it's actually statistically or statutorily required to understand civil legal needs in the context of this nexus. A disclaimer is that the opinions, findings, and conclusions expressed here are not those of the authors and not those of the Department of Justice or NORC. And then before I jump in, want to recognize my colleagues, Professor Sandifer and James Tufel. Particularly James has been in the trenches of this project, and I think on some days would probably prefer to be digging trenches rather than be in the data trenches. And so this work really comes out of the need for us to better understand what existing surveys say about this nexus. And so I'm going to offer 3 insights very briefly that reflect our improved understanding. So one is that, and I think those of us who are legal needs survey geeks sort of understand this. Criminal justice problem experience is strongly correlated with civil justice problem experience. And a little bit of data on that. So we looked at 3 surveys that explored the experience of both criminal and civil justice issues in the US. One is a 2021 survey that Professor Sandifer ran with YouGov. That data has not been made public, but it can be, I believe. It was sort of a COVID project for Becky, was one source of data. The second is the World Justice Project's 2018 and 2019 survey. And then we also used the 2021 LSE Justice Gap survey. And so across the 3 surveys that explored this nexus, we found experiencing a criminal justice issue is associated with at least a 20% increase in the likelihood of having at least one civil justice issue. And so you might wonder sort of how each of these surveys defined this criminal justice experience, and it's not straightforward. And this is obviously because different surveys are using different definitions and different clusters of questions. It's not a perfect science. But in the YouGov survey, criminal experience was defined as participation in a court case over the previous 5 years as a crime victim, crime witness, or criminal defendant. And the window for that civil justice experience was 2 years for that survey. In the World Justice Project survey, 4 responses were used as proxies for criminal justice experience. One was threats to physical violence from a current partner, ex-partner, or household member. The second was problems with gangs, vandalism, consumption of drugs or alcohol in the streets. The third was being beaten or arrested without justification by a member of the police or military. And the fourth was being harassed, threatened, extorted by a mob, gang, or other criminal organization. So again, we're having to find these questions and across these surveys. And then finally, in the analysis of the LSE survey, we looked at 4 areas. We looked at expungement, courts, fines, and fees resulting from a criminal or juvenile case, being a crime victim, or a victim of abuse, stalking, or sexual assault, and a domestic violence or partner violence. So from that, we determined that there's about a 20% increase in likelihood of having a criminal justice issue. The second insight was that identity and life experiences shape justice experiences. Again, I don't think that this is necessarily something that would be a surprise to any of us. But past research has often examined questions of age, income, and disability experience. A new set of research that was conducted by Catherine Young and Katie Billings in the US, the intersectional examination of US civil justice problems, further explored the intersectionality of additional characteristics like LGBTQ status, experiencing crimes, age, being a victim or witness of violence, and then looked at sort of intersectional ways of understanding that problem experience. So we replicated and extended the findings from that survey to the 2021 Canadian Legal Problem Survey, just to understand from more of a comparative perspective. And the most consistent predictors of civil justice events in Canada and the US were younger age, being a victim or witness to violence, and experiencing arrest. So again, seeing that correlation, that nexus between the two. Additionally, being LGBTQ+ and having children were as consistent, if not more consistent predictors as the level of income and disability status. So again, broadening the range of identity characteristics helps us to better understand these experiences. And finally, we looked at, I'm sorry, I should have been on that slide. Collateral consequences of criminal events are associated with having other types of civil justice events. So here, for example, in the 2021 LSC survey, weighted reports of an experience of an expungement in the last 12 months of the respondent or someone else in the household increased the odds of reporting a household experience with all 8 areas of civil legal need that were tested. And so I'm almost out of time, but I wanted to leave with, I think, 3 takeaways. One is that we need to better understand both how civil justice problem experience leads to criminal justice system involvement, as well as how criminal justice system involvement leads to criminal justice or civil justice problem experience. The second is building from the Young and Billings study. I think we need to better understand disparate criminal and civil problem experience across more diverse identity characteristics, and also the intersectionality of these characteristics. So if you're Black, LGBTQ, a woman who is young, the chances that you're going to experience a civil justice problem is exponentially more than potentially any one of those characteristics. And then finally, as I started with, the relationship between civil and criminal justice problem experience, it matters both for civil justice policy and for criminal justice policy. And we really need to de-silo both the research and the policy making across both of those areas. Thank you.
Okay, I hope everyone can hear me. I didn't take my inhaler the last 2 days because it was giving me laryngitis. So the options were I had no voice or I would cough. So you're going to get the cough, but hopefully I have some volume. I elected to sit because I thought if I stand, it's going to be harder to stay to 7 to 8 minutes. If I'm sitting, maybe I'll be faster. I wanted to present on a recent 2022 survey and paper that I co-authored with Professor Gerard Kennedy, currently from the University of Alberta, who's actually sitting at the back, if you want to, who's pretending he's not looking. We conducted survey and wrote a paper called The Access to Justice Needs of Manitobans Legal Professionals' Views. The paper actually just came out in preprint a few days ago. So the link is there. It's not in final form, but the preprint, I've added the link. And so what we did was we decided it would be appropriate to ask Manitoba lawyers, including articling students, their thoughts and views with respect to access to justice and unmet legal needs. We undertook this research right after I became the then titled Access to Justice Coordinator in Manitoba, a position funded almost entirely by our Manitoba Law Foundation. And at the time, Professor Kennedy was housed within the University of Manitoba. Now I'm housed within, I was previously housed within the Law Study of Manitoba, now housed within the Faculty of Law, and Professor Kennedy is currently at the University of Alberta. When we decided we would undertake research and surveying research, we decided we would interview lawyers and articling students, number one, because our Manitoba Law Foundation was currently undertaking a replica survey of the National Legal Needs Survey within Manitoba with permission from Justice Canada. So we knew that interviewing or surveying the direct user was already being undertaken, and we wanted to give Manitoba lawyers the ability to provide their perspective. So I'm going to just highlight a couple key findings. The most noted area of need in terms of practice area was family law, seconded by criminal law, and then third, child protection. I should say that the survey questions that we asked were almost a replica of the questions that were provided to the Saskatchewan bar in a survey that Bree Lowenberger and conducted through the University of Saskatchewan. So thanks to Bree for her assistance in the questions. In terms of ideas for breaking down some barriers, the prime or the most commonly given response was to increase funding for free or subsidized legal services. So in terms of limitations, as I mentioned, we recognize that it would be difficult to get a sample of lawyers that's statistically representative. But we did get 124 lawyers respond. And in terms of our Manitoba bar, our lawyers and articling students, it's 2,186. So we had a response rate of about 5.6%, unfortunately lower than Saskatchewan had when they conducted their survey. In terms of ethnicity demographic makeup, it was proportional to the Manitoba bar itself, but not representative of Manitoba broadly. And the samples were small enough that we couldn't really pull data with respect to the composition of the respondents. But what we could pull was with respect to where they practiced. So of those who responded, about 58% practiced in family or in private bar, but we did get responses from provincial and federal lawyers, in-house counsel, and community-based lawyers and legal aid lawyers. In terms of practice or experience, the respondents range from less than a year of call to over 30 years of call, with approximately 4% being less than 1 year. So articling students to the majority, over 20%, being greater than 30 years in practice. So the respondents were roughly divided on whether justice-related problems should be resolved through formal justice systems, but really that answer should be taken in cohort with the next slide, which is the overwhelming number of respondents agreed that the vast majority of justice-related problems could be resolved outside the formal legal system. Now, I won't, for the sake of time, highlight all the data on this slide. You can read the paper if you're interested, but I wanted to highlight an interesting point on this slide that 51% of respondents indicated that only rarely do individuals have the ability to satisfactorily resolve their justice-related problems with minimal financial expense. As I noted earlier, family law was overwhelmingly chosen as the area of law in greatest demand, and then by criminal law and child protection, which was different than the results that came from Saskatchewan with that same question. I won't read all of the causes of why that might be, but the vast majority of lawyers responded that the reason for family law lack of access to justice was due to a lack of low-cost legal service provider in the area. Though I will note that our legal aid services in Manitoba do cover most family law matters, so long as you fall within the required financial eligibility. In terms of possible solutions, the vast majority of respondents indicated that increased free or subsidized legal services would be helpful, and 34% of interestingly indicated they'd like to see legal service expanded by allowing limited scope practitioners with limited license who were non-lawyers, which was a positive amount to see from Manitoba lawyers when we thought there might be more hesitancy with respect to that. In terms of social groups, low-income earners were identified as the social group most in need of legal services. I'm going to start going really fast now. Sitting didn't help me at all, clearly. And most importantly, I think we gave all respondents the ability to comment however they saw fit in an open-ended question on their thoughts on access to justice. And there was a number of lawyers who commented on the unique and necessary needs that come from rural and northern Manitoba, specifically the north. Winnipeg, for those who don't know, is located an hour from the US border. So we have a vast amount of land towards the north of our province. A number of lawyers commented on our changes to family law, and how that can be improved, and increase funding to, oh, that's my timer, increase to legal aid funding, and I'm happy to chat further. And our contact info is there at the end if you wanted to chat with us outside of the conference.
Great, thank you. It's called self-accountability.
Yeah.
Well, I'll stand up here. That way I'm close for the accountability perspective. Thanks, everyone. I really appreciate being here, and I'm here today with an initiative that is, I'm on the Legal Needs Surveys panel with an initiative that is a grateful recipient and user of legal needs surveys, and as well, a bunch of the work that you've done in the room. The Law Foundation of Ontario has started this initiative. It's really interested in a modern and inclusive way to describe the access to justice impact of its funding, of the work of its grantees, both individually and collectively. And so what I want to do today is share with you where we are on this project, what we've done over the course of the past year, and talk a little bit about some of the challenges that we are surfacing as we embark on this endeavor, some challenges that I think we share. So the project was designed start with a sort of a refining of the definition of justice and access to justice. So spoiler alert on the challenge part. And then to build a theory of change that would link the work of the Law Foundation and of its grantees to that achievement of that definition of justice, achievement of the definition of justice and access to justice, and then build a measurement framework that would allow that the contributions from all of that work to be aligned to that theory of change. So I'm going to hustle through the first 3 slides because they lay out the challenge, the foundation of the challenge that we all know. First, that the construct of access to justice is evolving. It's complicated. We all know this. We're talking about it. Second, that there is such great work out there. As I said, we are the grateful recipients of all of this work, understanding needs, understanding impact. And third, that there are as many views and opinions and experiences and perspectives on justice and access to justice as there are trees from the view from this window. And so, with that foundation, we began to sort of try to pull it together in a way that would help us build this framework for the Law Foundation. And so here's what we've done. Obviously, we started with all of your work and we conducted quite a deep review of the national and international work. And we've been absorbing all of the work that you've presented here as well. And we built what we've called colloquially a bit of a primer. Then we began to talk to people using all of the work that you've done as a foundation for the reasons to talk. We conducted a survey during last year's Access to Justice Week. We built advisory committees of grantees and another advisory committee of academics and thought leaders. And a number of you here in this room are on one of those 2 groups. So thank you very much for your contributions. We conducted, as part of our primer, a work on the legal needs, on all of these legal needs surveys to create some perspectives based on the voices of recipients of justice work, not just the voices of justice service providers. We began to have consultations with some of the people in communities that in Ontario that might not have surfaced through some of those legal needs surveys that we already spoke about. And so just, because this is a room full of researchers, I want to reiterate that we're not holding out that this was a massive or representative kind of effort, but rather conversations to gain a little more insight, to gain, to build even another layer over all of the work that already exists and that you've already done. I just wanted to, sorry for the very wordy slide, but I just wanted to provide a little bit of some of the justice perspectives that came out of those conversations, which I think align very well to the work that we're hearing and the common themes that we're hearing about. Legal problems are life problems. That is the most common theme that came out. When we think of them as legal problems, people who are experiencing them are experiencing problems in their life. This is something you all know, right? Trust is a crucial element and was the thing that came up most in terms of conversation. We care about trust. And conversely, we don't necessarily trust the system. A significant number of the people whose voices we were trying to listen to felt that the system was unjust for a variety of reasons. And finally, a number of people talked about the collection of intersecting challenges that they experience, whether those are medical and legal, whether those are digital. You know, we talked yesterday about the intersection of digital capacity and legal capacity, right? Intersectional challenges in a very broad array of ways. And so, you know, this based on all of the, you know, I really skimmed over massive body of work because you know the massive body of work, you've conducted the massive body of work, but based on sort of trying to absorb all of that and turn it into a framework, this is where we are in a current working draft, high level theory of change. You know, the idea that justice is a component of well-being, that people need to live a good life, and that access to justice happens when people are equipped to support their well-being. And so we identified 4 outcomes that, you know, access to justice outcomes that contribute to that impact and to that vision. You know, outcomes of all of our work, right? When we contribute to individual behavior change, when we increase access, when more people, more issues, more dialogue can be surfaced and supported, when the people who are doing the work have greater capacity to serve a greater number of people and respond to a greater number of issues, and when we shift the overarching experience. So, you know, sort of picking up on Carrie's question earlier, at some point, when do we actually begin to shift the whole experience for all of us? So right now, we're at the point where we're working with our grantee advisory group to test measures related to the bottom 2, right? Related to the outcomes and the outputs. And we developed a set of measures. We're sort of high level right now, seeing whether they work, right? Are we collecting data that supports this? Is it collectible? And when we collect it, does it actually even tell a story that helps us here? But while we're doing this bottom half of the work, we are still wrestling at the top with our concepts and our constructs around justice and access to justice. And so this is the shared challenge I wanted to leave you with. These descriptions, and I put them over on the one side there, of justice, they're pretty lofty, they're pretty broad, and they present some really real tensions that we're currently wrestling with. And I felt us discussing them as we go. I might have also titled this slide, how the heck do we define justice and access to justice in a way that actually resonates, that helps, that isn't too narrow, that isn't too broad, that isn't self-serving, that isn't exclusionary, that reckons with the real world, that allows our work to be seen, and should we even be trying to define it at all? That's really the title of the slide, because that's really very much where we find the tension when, you know, after all of this work, we come right back to these fundamental issues of where do we want to be talking about? We feel compelled to define it. We are word people. But this is, oh, I'm sorry. But this is such a big concept. It's, this is my last slide. And it is both personal and it's collective. And as you saw in some of my quotes, there are lots of us who feel that justice for me shouldn't be defined by other people. It should be defined for me. And so, you know, on the other hand, if we can't define it, how do we measure it? And so we really find ourselves in the, you know, these tensions. And I tried to describe the tensions with my creative alliteration there around perspective, priority, and purpose. And I think we've been talking a little bit about this as we go, the perspective of people seeking justice versus the perspective of people working in justice. That already creates a different view of the definition. What is your immediate need, right? That's going to define your view on what is justice and your view on what access to justice looks like. And why do we want to use a definition? Why do, you know, that very much will define, you know, and should be a pretty critical priority for us on what it is that we're surfacing. Are we using it to describe? Are we using it to evaluate? Are we using it to fund? Are we using it to measure? Why do we want to use it? And what will we get out of it? And that purpose also is something we're wrestling with when we're trying to make sure we're defining it. So that's where I leave you in a, you know, right all the way up at the end in a conundrum that I think is a really good one. We're in the conundrum because we all care very deeply about the work that we're doing and the people that we're serving, and we want to make sure our work is getting it right. And so I really very, please come and find me afterwards if you have ideas on where the level on this definition should land. Thank you.
Great. And now we're going to turn to our virtual presenters, starting with Heather Heavin.
Fantastic. Thank you, Matthew. I am just wondering, can you see the screen? I believe I have share screen, but I'm just double checking.
I'm sorry, can you say that again? We're just figuring that out. 1 second.
Okay, tell you what, I have been texting with the tech. If he could just put my screen to the very first, that would be
You're all
fantastic.
set.
Okay. All right, thank you so much. And thank you, everyone. My name's Heather Heavin, and I want to talk today about measuring improvements to access to justice using an access to justice measurement framework. And I'm doing this in a particular context. Now, this session is about legal needs assessments and measuring improvements to access to justice. And we've heard from several speakers so far about different legal needs assessments, challenges. Obviously, Meredith talked about challenges with defining access to justice. And also, we've heard about integrating information from different sources to more fully understand the justice sector and our justice system. So in the next few minutes I've been allotted, I want to talk briefly about a research project that Bree Lowenberger and myself, along with 2 social science researchers employed at the Center for Forensic Behavioral Science and Justice Studies, we just call it the Forensic Center, here at the University of Saskatchewan. It was a project we undertook to better understand legal needs in Saskatchewan. And in particular, I want to focus on how we analyzed some of the data in one part of the study by using an access to justice measurement framework. We used in particularly the BC Access to Justice Measurement Framework, or at least we credit BC in developing this, British Columbia for the Americans in the crowd. And this adopts a triple aim approach to defining and measuring access to justice. And the 3 aims are, number 1, to improve population access to justice. Number 2 is to improve user experience within the justice system. And the 3rd is to improve costs, either on an individual or on a per capita basis. So a triple aim. And for those of you that are familiar with the healthcare system, these 3 may seem very, you might actually pick up on them, because the triple aim approach, the access to justice measurement framework, took a lot or borrowed a lot from the healthcare sector. So we wanted to highlight this unique aspect of our study because of the current interest in the access to justice measurement frameworks, as has been discussed, but also because we have been using this particular measurement framework for program evaluation and for research projects that have been undertaken at the College of Law and through Create Justice for the past 6 years. So this morning, I want to talk about the use of this measurement framework in one of these projects. So what is the project and what did we do? So in 2021, the research team of Bree Lowenberger and myself wanted to get a more accurate understanding of the legal needs in the province of Saskatchewan. Oh, sorry, I will ask you to advance the slide just by one. We wanted to adopt a multi-stakeholder approach to legal needs assessments, and we did so by surveying both lawyers, and Natasha Brown out of Manitoba, as she said, replicated that survey in Manitoba. So we did a survey of lawyers to get information about their perceptions of legal needs in their communities and in their practice and service areas. But we also did a survey of community service agencies. We wanted both of those perspectives. And this timing of the project was very intentional. it was structured to coincide with StatsCan's one-time Canadian Legal Problems Survey, which was getting information from the public or users of justice services. So getting user experience from the StatsCan data and then our two surveys, we were able to generate data about the legal needs in the province. As part of this project, we also undertook a legal data scan, and that's what I'm going to be talking about. We wanted to know what data justice sector organizations in Saskatchewan were collecting and what they were making publicly available. Okay, so that public availability, what they were reporting to us, and whether or not that publicly reported data could tell us something about improvements to access to justice. So this part of the study was a bit of taking stock. So the legal needs assessment is generating data for us, and this one is looking at really what we already have and what we're already collecting and reporting on. So I think many of us in the room would agree that the ability to make data-informed decisions about interventions and initiatives in the justice sector are often hampered by an inability to access good quality data. And this is in part due to the lack of capacity to collect that data, a lack of capacity within the organizations to analyze the data, a lack of legal infrastructure, such as data sharing agreements to facilitate the sharing. I think Matthew said we silo. So how do we share data between organizations? We lack common collection points for data, or and this is related, we lack common metrics upon which to measure the impact of a program, intervention, service delivery model, you name it. So in the legal data scan part of our project, an environmental scan was undertaken of the annual reports published by 24 justice sector organizations in the province who offered civil and family law related services. Additionally, we then followed up with 14 key informant interviews of representatives from these organizations to gain a more in-depth understanding of the types of legal data that was collected in the province and what opportunities might exist for more robust sharing and utilization of existing data, as well as perceptions regarding something that's near and dear to my heart, the need for the creation of a data commons among justice stakeholders within the province of Saskatchewan. So I'm going to flip ahead a bit in the slides. If you could take me to slide 6. So how does an access to justice measurement framework or the triple aim approach fit into this aspect of the study? So the data from the environmental scan of publicly reported in annual reports data and information that's being collected by these agencies, the environmental scan analyzed that information under 2 lenses. We first did a content analysis, what is being reported, what's the type of data that's contained and published in the annual reports. But we also applied a second analytical lens. We looked at that information, that data, and said, how does that fit within an access to justice measurement framework? As I mentioned, we were using the triple aim approach, and we looked at the 3 elements. We looked at what data is being reported that speaks to improving the population access to justice, what data is being reported that talks about improving user experience, and what data is being publicly reported that's talking about the costs. So for those of you that might be familiar with the triple aim approach, these 3 broad elements are then divided into further components and dimensions. And I'll talk about that in a minute. So why did we do this? Well, why not, right? We wanted to try it. We had the information, and we've been talking about metrics and how to measure improvements to access to justice. So let's see how well existing data might be able to be explained or be explaining whether or not initiatives or work that's being done by this agency is moving the yardstick forward in one of these 3 areas. So we recognize that often there is a lack of data or lack of consistent data. There is a lack of consistent collection methods, and then as a result, the metrics can be difficult. So reporting that's not collected or reported or standardized in any ways, we know makes comparability very difficult. Second, there is often a narrow focus on the data that is being collected and reported. So when you do a content analysis, you're often finding that we're measuring inputs or outputs, such as the number of cases, number of clients, number of decisions, number of hits on a website, but it doesn't report necessarily on the impact things are having. So by analyzing reported data using this framework, it provides us an opportunity to think about what information is collected by thinking about why we would collect information in that way. What is important about collecting that type of data? What questions might it answer? But I think it also makes organizations think a little more clearly about the objectives or the goals that a particular access to justice, intervention, or innovation may seek to attain. So I'm going to just highlight one of the elements, and if you could move forward to the next slide. I mentioned the triple aim approach, so the improving population, improving user experience, and improving costs. I mentioned that there are several dimensions or subcomponents that we can turn our mind to when thinking about how we might define what we mean by improving, say, population access to justice. And I will say I'm going to focus only on that because I have limited time, and also because very few, and I will say under improving costs, out of the 24 agencies publicly reporting data, only 2 were reporting on costs, and in a very narrow way. Nobody was reporting on individual costs or on per capita costs. They reported not surprising, not-for-profit agencies were reporting on cost savings in terms of the value they were providing by providing no or low-cost legal services. But I'm going to then
Heather,
focus.
I'm sorry to interrupt you. I'm not sure if you're seeing the chat, but you're over time. So if you could wrap up, that would be fantastic.
Okay, you know what? Then
Apologies.
I won't mention that. I will say read our project. I want to say I will just wrap up by saying the purpose of this was really a driving impetus was that we want to work to establish a justice data commons in the sector. We find that the access to justice measurement framework provides a very useful analytical lens within which to see how helpful this might be as an organizing principle for agencies to start reporting on these metrics, but also in starting to change collection practices so they could be more fulsomely measuring whether these initiatives that they're engaging in and the services that they're providing are actually moving the yardstick forward on improvements. Thanks.
Thank you. And next up, we have Luis.
Yes, thanks. Can you hear me all right? Is that good?
Yes, perfect.
Okay, amazing. Thanks for having me. I'm sorry not being able to be there with you, but super happy to share our work with you all. On that topic, I'm going to talk about our research that we've been working with Ernesto Cárdenas on the 2020 Colombian Legal Aid Survey. Just as a bit of context, that is a nationwide household survey, the second of its kind applied in the country, and we just have results of it. And we want to explore a couple of key insights that we were kind of focusing on decision-making, and not necessarily just from a descriptive side, but rather on asking questions about causality and what the survey can allow us to understand on access to justice in the country. So if we can move forward, please. Yes, the main motivation here is that strikingly within the results, we found a lot of inaction when individuals face legal needs and justiciable problems. The main idea is that most than half of those issues when faced are not acted upon. And you can see that flow is particularly heavy on crime-related issues, but it's also relevant in civil issues. And we were trying to understand why that was happening. And just as a disclaimer, we do not consider inaction as a bad thing per se, but we want to understand why that's the case, that why we are seeing such a high levels of inactions within the populations. We are studying around 8 million individual justiciable problems declared by almost 6 million individuals in the country. So that's kind of the core issue we were facing. Next, please. And that is important for us because we know there is a relationship, at least descriptive, between inaction and poverty. Here you're seeing the link between the access to effective justice index. That's a measure we made for effective justice access, and the departmental average of the multi-poverty index in Colombia. And as you can see, there is kind of a descriptive link within it. And most concerning for us was the fact that inaction leads to lower solution rates or around 40 percentage points relative to self-action and positive action on the side of individuals. So that's a heavy insight on how and why we're looking into this. And next, please. And the main reason we look into the survey for this, but the main reason most of those inactions were being present in the population was the perceived cost of accessing justice, and also this idea that processes are lengthy. And that's kind of the core of the research we've been building. How are individuals actually assessing that length of processes from the start of the legal need or the justiciable problem to the configuration of the legal need up to the solution of it. And solution in terms of not only verdict, I will say, but rather the problem being solved. So next, please. So that's why we started building this notion of, probably because, as we all know, legal needs and justiciable problems are really complex and they happen in an intertemporal framework. So the first time an issue arises is not the same time where individuals are making the decisions to act upon them, and also are not the same times when the resolution are being observed, perceived. And as you can see, this is a highly complex path from the start to the beginning, and the decisions between those paths are really important for the definition of which action individuals are making. And we are guessing that there's also transversal elements to it, like self-efficacy, legal empowerment, choice alternatives, and objective conditions, like, for instance, the availability and access to formal institutions. So it's a complete path, and we're trying to see how we can study that better, and just not taking for granted the fact of on this main idea that the need happens and then we just have an action to solve it. And to that end, we built, next please, sorry. To that end, we are building on a couple of ideas that there is emotional prospects at stake when making those decisions, that there are economic barriers, and that there is perceived efficiency and trust on the systems are going to be really heavy determinants on that. The issue is that the survey is not really built for taking those assessments. So we try to work around by implementing a different methodology than just looking at the results. Next, please. And to that end, we use Tutela as an exogenous source of variation. Tutela is this legal tool that was implemented in Colombia after the 1991 constitution that allows individuals to actually face a more certain path to justice, because by law, judges have at least at maximum 10 days to respond to the tutela. So it's kind of a really express mechanism that breaks that uncertainty. And importantly, it was a random chance. It happened through regulation. People were not expecting it. So it's kind of an exogenous variation that we use to actually pinpoint this notion of certainty in the justice path. Can we move, please? To the next one. And so we built a regression discontinuity model. And the main idea is that we are comparing individuals on the side of the exogenous change and near and close to it. So those born before tutela was implemented, those born after tutela was implemented, and we want to compare the future actions they took on accessing justice given the exposure to treatment. To that end, we just narrowed a bit of data points showing certain legal problems that were not really that well represented within the survey, but we were able to find a lot of really interesting things. The main idea was that bringing this certainty within the system actually reduced inaction in about 7 percentage points for some individuals close to the margin. Can we move to the next one, please? And we also tested for many falsification tests within the methodology. We control by individual characteristics and also by problem level characteristics like topology, impact, and demographics and socio-demographics. This is just to show you that we were able to actually try to falsify the results, and we would find them to be robust to many of the methodological details on it. But most importantly, just to close up. Next, please. What we want to mention next, this is another falsification test. We can move, please. So just to wrap up, the main idea is that we are finding effects on certainty and clarity of procedural times and cost under inaction. So being more clear about how the problem is going to be solved, the times is actually now given evidence actually impacting inaction rates. And this connection is not really that evident within surveys because they are not designed to validate policies or instruments. But now through this quasi-experimental method, we found a bit of evidence of it. There is a lot that could be behind this and that we cannot control. For instance, legal capabilities, efficacy, that's not measured in the survey. But what we're guessing is that there is also a connection between those possible latent variables and the engagement in resolution of issues. And that's important for further research. And at the end, what we're trying to do is shifting the focus of not only trying to develop these objective conditions like mechanisms like tutela for accessing justice, but also asking ourselves what do people also need to be able to use the mechanism. And the main idea is that we don't find a huge effect on it while being positive and statistically significant. There is still other factors driving that decisions to act upon problems. And that's kind of the next steps we're trying to build on the 2022 survey that's just coming out recently in Colombia. So that was all from my side. Thanks a lot.
Thank you. All right, we now have a good amount of time, about 25 minutes for questions. We don't have any questions yet from virtual participants, but I'll keep monitoring that. So we'll take questions in the room to kick things off. Everything was so clear. I thought there's no.
The panel was fantastic. Thanks a lot to everybody. I wanted to just lob two brief questions to different folks. To Daniela on identifying access to information as a key sort of barrier or pain point. Are you able to dig down at all on whether the problem was that people didn't know that information existed, or that people just didn't access it? So that's one thing I'm curious about. And then to Natasha, and maybe also to Heather, in terms of the legal practitioners identifying areas of need, I don't know if I saw a slide on this, so sorry if there was one. Could you do any, or were you able to do any matching between their practice area and the problems they identified? I know you sort of had practice context, law firm or other things, but I wonder if there's any relationship between if you practice in an area, then you see the need in that area, sort of thing. So just whether those surveys are able to catch that.
Thank you.
Can you hear me? Okay. No, thank you for the question. Yeah, unfortunately with this, well, we basically look at the outcome of having accessed good information and advice, but we don't necessarily are able to tap into whether there was capability to access that information and advice. Yeah, it's for future survey work. Thank you.
So Sorry, now my voice is starting to go. My quick answer is we don't have that data. I suspect anecdotally, because our family bar is very small, that what couldn't possibly have been just family law lawyers who responded family law just to make up that volume. But in terms of a direct question with respect to the correlation, we didn't have. I don't know if Saskatchewan or Gerard, do you want to add to that?
Yeah, very quickly. We didn't precisely correlate it, but we do know that there was a disproportionate number of family lawyers who responded to the survey, not to such a degree that it could have explained the extent to which people thought family law was an underserved area, but the respondents were disproportionately litigators in general, which would include family lawyers. Sorry, I didn't mean to interrupt you, Natasha.
Thanks, Gerard.
And I can jump in as well. So we asked several things in the lawyer survey, kind of about where they practice. We were also trying to get at geographic location because we wanted to be able to discern between whether if you were practicing in the north versus practicing in southern Saskatchewan, whether in an urban center, whether or not there were certain different legal needs that you were, perceiving. We did try to separate between whether people were working for the provincial government, working for legal aid, working for pro bono legal services, or working in private firms. So we did have that kind of distinction that we were able to wet out. Ours was a little bit different because yes, family law was high on the survey, but it wasn't the highest. So we're a little bit different than what Manitoba had in terms of what the lawyers perceived. But interestingly, other things that were high, such as housing issues, money and debt, social assistance needs, immigration, these were very high, and I don't think they don't necessarily reflect the practice areas that the lawyers that were surveyed were experiencing, because we did try to frame the questions on having them focus on kind of in general where they see those needs in their communities, but also, in their regions. So I'm not sure if it was perfect to try and get at that, to get away from that bias, but we tried.
Great, thank you. Emily.
So this question is from Matthew, and as an American who gets very frustrated at the lack of national legal needs data, I'm wondering, based on what you've experienced with BJS so far, any thoughts about how we can politically mobilize to get more support for legal needs data in the US?
Wow, that's a good question. I mean, I think this is a start, right? I think it's been very helpful to have a newly reconstituted Office for Access to Justice in the Department of Justice, and that team is actually quite large now. I think it's more than 40 people. I think it's helpful for researchers to make the case in those contexts. And Emily, as you know, we have a NSF-funded workshop that we held with access to justice researchers and federal agencies in DC, which opened up new lines of communication and opportunities for advocacy with the federal government. I think a lot of those challenges aren't just about the desire to share data, but also some of the complexity of sharing data and the quality of data that's being shared. So those things are being addressed as well. But I think we just keep working on it. And I think, it's really wonderful that the Bureau of Justice Statistics, which is always focused on criminal justice statistics, is interested in this and sees the clear connections between civil and criminal justice problem experience. Thanks for the question. I'm going to take one. We do have one question from the chat. For Manitoba and Saskatchewan, what ideas did you hear for increasing access to justice in northern and rural communities?
Generally speaking, there were some lawyers on the general comment section who spoke about the importance of incorporating the principles of the calls to action of our Truth and Reconciliation Commission more fulsomely into our work, and incorporating the principles of UNDRIP, the United Nations Declaration on Rights of Indigenous People. and to better collaborate with community organizations in terms of building upon the connection of already trusted sources within the community. So those were a couple of the suggestions, but some were consistent with the same suggestions made just generally in terms of increasing service providers. Some lawyers commented on the lack of lawyers who practice in Northern Manitoba. So working towards increasing the number of lawyers who are able and willing to practice in the North. I'll turn to Saskatchewan. I won't keep talking.
Sure. So when we analyzed the results of this, we dug a little bit deeper and then did, took qualitative responses as well as quantitative from in the survey. And what we did is we looked at kind of the top 3 areas that were identified as legal needs, and then had the survey recipients dig deeper into solutions or what they thought might actually be helpful. So it differs a little bit depending on the type of legal need that was identified. And of course, we weren't looking at necessarily social, like what actually could we do? So an example would be in housing. That was recognized as a significant legal need. It was kind of the within the top 3 in terms of trying to have greater housing supports. Of course, one of the recommendations is to have greater scope for low cost or no cost legal services within the province. Not surprising. We're always calling for enhancements to legal aid or other types of supports for people. One thing that we saw and was asking for increased collaboration between legal and non-legal service providers in this particular area. Oh. Something's happening, an emergency alert in Saskatchewan. I'm not sure what that is. Okay, and so that was interesting because it was really saying we need to rely on things outside the justice sector and service providers out there to actually meet what that legal need might be. Also, and which was mentioned before by Natasha, was looking at alternatives, alternative fee models, but also alternative practice models where you could provide limited scope retainers or limited services so that you could help people, maybe with advocacy, maybe before the Office of the Residential Tenancies or what have you, to try and actually have targeted interventions where they make sense, but that would take away from kind of full scope retainers, which people can't afford. So I would say we do have a range of possibilities, and interestingly, at least we couldn't find a huge difference there. I don't think we had enough results to really say that was a big geographic difference, because we recognize that, say, housing is an issue all across the province, whether you're in the north or in the south or in the urban setting. So that was a little bit harder to tease out.
Great, thank you.
Hello, my name is Mandavni Dhammi, and I'm an articling student at Parkdale Community Legal Services. My question is for Natasha. You mentioned that your sample wasn't representative. I'm wondering if you could speak more on that. I'm thinking about how part of the access to justice, one of the access to justice problems that we have relate to specifically who has access to the legal profession and who is a legal professional, specifically, various different identities, but especially in terms of race and ethnicity. So I know that as you were speaking, I kind of was looking into that in Manitoba, and I came upon some news articles that have specifically mentioned the race and ethnicity problem in terms of a lack of representation in the legal profession. So I'm wondering what your analysis was of that when putting your findings together.
Well, I can say it would take me just a minute to flip to the exact numbers, but in terms of, is our bar representative of the diversity of Manitoba? No. And that is a passion project of my own, separate and apart from me, to tackle one day. In terms of were the respondents consistent with the proportionality within the bar? Yes. So in terms of the number of Indigenous respondents that responded, the percentage was representative of the number of Indigenous lawyers who practice within Manitoba. Now, that being said, are the number of Manitoba, Indigenous people in Manitoba in a proportion to our province the same as within the bar? Not even close. I don't have that statistic, obviously. And I know that's work where we have to do better. I don't want to speak to things I'm not an expert on, but as someone who is a member of a historically disadvantaged group myself, that working towards remedying that is significantly important to me. And so I know at the Faculty of Law, unrelated to this research, we're doing more research in terms of partnering with the University College of the North to try and increase the number of Indigenous students while in high school years and undergrad to consider entering the practice of law. We've just hired a director of, I don't want to get her title wrong, she started a couple of weeks ago, of an internationally trained lawyer program in equity and diversity to try and work towards assisting us on faculty with diversifying who gets to have a seat at law school, which will then ultimately change the demographic of the profession. But for the purposes of this research, all I can say is the proportion was consistent with the representation in our bar in Manitoba broadly.
Thank you.
I'll just add an antidote to that. So one of the research projects we're focused on is community justice workers who are non-lawyer advocates in Alaska who can provide legal advice and representation under a waiver of the Supreme Court. 30% of those community justice workers are Alaska Native, which is overrepresentative of the Alaska Native population in Alaska. And I think the ALSC, the legal service providers, are around 12%. So I think the solution here is not just a pipeline problem, it's also thinking about the diversity of justice workers that exist. If we really want representation from individuals and communities, it's more than just shaping the bar or shaping law schools. It's about reframing who's doing justice work in community. Well,
Andrew Pillier, Thompson Rivers University. I wanted to say, first of all, Meredith, I appreciated seeing well-being so prominently focused in the definitions of access to justice and what to build towards. My question is, I think, primarily for Daniela and Luis, as and jumping off of Emily's question, as places where there has been multiple iterations of unmet legal needs type surveys of doing it no more than once and beginning to be able to see patterns and ongoing work, how do you do it? Any tips for institutional support for that, not just once in time, but repetitive iterations? Thanks.
Thank you. That's an excellent question. So our legal needs survey we have been able to iterate the legal needs survey only in 5 countries in Latin America. And that was honestly almost idiosyncratic, the way we ended up being able to land funding. Usually it's sort of allowing the legal needs survey module piggyback in the general population poll from, depending on the interest of the funders, whether there's maybe some leeway to have some flexibility in terms of the thematic interest that they have, but if you all have any ideas, we would we would definitely welcome. Thank you.
Yeah, I can add to that answer. And I believe in the Colombian experience, there has been a critical contribution of the judiciary and the private and the executive branches of the government into coming together and actually realizing the relevance of the data that the legal survey can bring. But that's just not enough. As Daniela was mentioning, budgeting and actually having the resources to do them is really important. The way we've done that is incorporating the need for legal needs data, people-centered legal needs data, in our national development plans. So those are kind of planning instruments that are developed for 4 years. Every time a new president is elected, he or she is meant to do actually those plans. And within the institutions, we come together and start building kind of this political line actually to have future within the survey each 2 years or so. So bringing that into the kind of stakeholder radar is quite important for us, because many good intentions are put into place, build the formula, the questionnaire, setting the sample sizes. But at the end, if you don't have resources, it's going to be really hard. So that's one. And the other, just to close up, is actually presenting the results for those who can use it. Because often when you see your investment as an institution in the government, you want to see the results. So bringing that value to the stakeholders, that is the judiciary, the Ministry of Justice, the different programs, and presenting the results of the survey as a different way to approach complex situation, to give another diagnosis of a really complex part of justice. I believe that's how we have been able to actually sustain the operation in time. Yeah.
And no, that is an excellent point, Luis. And just to add up, I think that yeah, what you just read is crucial in the sense that because in a way we could end up with several iterations of legal needs surveys that at the end no one really used. So in a way, it is about getting precisely like the engagement with justice actors. Sometimes there's gonna be likely like maybe we can try to achieve a core set of questions that maybe we can sustain and then have adaptations depending on the interest of justice actors that are actually going to use the data. And in a way like that involves bringing them from the very beginning of the data collection process. I think that's sort of what we are also trying to do in the World Justice Project.
I think they're also great. There's political momentum at the policy level through OECD, which has built research and evidence component to their people-centered justice framework, the Justice Action Coalition, which has a working group on data and evidence. So I think we're beginning to see research, data, and evidence being built into policy formation, at least at the global level, which I think is very exciting and kind of emergent, but new and exciting. Thanks.
Hi there, my name is Miriam Roger, and I'm interested particularly in Matthew's response to whether you're in your analysis of looking at the correlation between civil legal needs and criminal experience, whether you looked at whether multiplicity of legal issues had any indications, whether it indicated more complex issues or more challenges around access to justice for those people who had overlapping, intersecting legal needs.
Yeah, I think it's that's common. We sometimes call that problem clustering or cascading legal problems, and it tends to be people with more complex lives have a greater number of legal issues. I think it's Hugh's in the room here now. One of the statistics from this conference last year that really sort of inflamed me was a small percentage of folks in the pulse survey, I think under 10%, maybe 6%, experience over 50% of the justice issues. That tells us something about how we should be designing justice system delivery if we're focused, too broadly. And I think there's sometimes policy kind of impulses around trying to convince people that everyone experiences justice problems, and we need to make sure that we're investing in the justice system to take care of everyone. But really, if it's the fact that a very small percentage of the population are experiencing more than 50% of legal needs, that's telling us something that I don't think our current system is really responsive to. But I don't know if you want to add anything to that.
Yeah, maybe one thing I'll add is on in our Legal Australia-wide survey, we had crime and civil and family ability to cover those issues in that paper. And we did look at that issue of the overlap. And it's pretty much exactly as you would predict. People experience higher numbers of civil legal needs, track as having higher levels of criminal needs, vice versa. We didn't try to work out the pathway at that stage, opposed to just reporting the overlap. But yeah, in answer to the question, yes, absolutely, that's exactly what we see. So we do see the really strong clustering of problems and related problems amongst a small proportion of the community, which tends to be more disadvantaged people, exactly as you would predict.
Thank you.
My name's Doug Wellman. I'm a lay board director of the Law Society of Ontario and co-chair Access to Justice Committee. And one of the projects we're involved in right now is trying to find ways of attracting lawyers and probably new lawyers to underserviced areas in the province. And that's a combination of the graying of the bar in these areas where a general practitioner is close to retirement, trying to attract someone to move in and take that practice and have some mentoring, and a combination of there isn't legal services to a large extent there now. So we've been gathering a lot of data on where these underserviced areas are. And my question is, and Natasha took a note that Manitoba is doing some things. You talked about a person who is looking at the international attraction of lawyers and giving incentives somehow to go to these areas of need. And you talked in Alaska of Matthew, some unauthorized services that are helping fill the need there. Any other ideas? We're not the medical association in Ontario that can give $300,000 for a new doctor to go to a remote area.
I think start with people who are already there rather than trying to attract lawyers, which seems like an expensive and complex thing. I think the trend is towards training and supporting non-lawyers who are already in rural and remote communities to, as I suggested, like Alaska, be able to provide those services. And all the evidence suggests that they're competent and capable of doing so. The audit surveys that have happened in England and Wales have been fairly clear about that evidence. In fact, non-lawyers, in terms of the audit, this was Richard Moorhead, performed above, exceeded performance of on routine legal issues than solicitors. So I think the evidence is clear about effectiveness. I think what we don't have a lot of evidence on is how do you scale these things and sustain them over time, which is, I think, emerging.
I might just add it as an idea, and I don't know if this will ever come to fruition. Maybe, I'm hopeful. The only law school in Manitoba is the University of Manitoba, which is in Winnipeg. So often lawyers or students who want to become lawyers who happen to reside in northern Manitoba have to come to Winnipeg in order to obtain their law degree or elsewhere to whatever other law school they wish to go to. And I don't have the data in front of me, but I know anecdotally from our director of professional development at the law school that only a small proportion necessarily return to their community to practice once they've come to the city to obtain their degree. So if we can do better in terms of bringing legal education to them within their own community than having them come hours away to Winnipeg and then showing them the glitz and glamour of our big firms, might help if we can think outside the box in terms of the delivery of legal education.
Can I just jump into, in Saskatchewan, there was a couple of things. I want to just echo what Matthew has mentioned. We did the Nunavut law program, or offered a 4-year law program in Nunavut. I guess the graduates graduated almost 2 years ago now, but that was incredibly successful. We had 24 students start, 21 graduated, and of those, 18 were Inuit. And so we increased the number of the practicing bar incredibly by bringing on and teaching in place. That was really important to bring the legal education to them so that they didn't have to move south. We aren't doing as well in Saskatchewan. We have needs in rural Saskatchewan. The demographic change in the age of lawyers is significant. One thing that we have just started with in partnership with the Ministry of Justice is a rural externship. And so we're actually partnering with legal aid, prosecutions, and this is a brand new initiative to give students clinical experience in these areas rather than just inner city clinics, but also having them go out into these rural, or we were calling it the rural and regional externship. And so this is one small way we're trying to change that and have the students do part of their training actually in the rural setting. We're not the medical association. We're going to see if this works. And as I said, we've just started it this year. So hopefully it will have some results and maybe we can grow it.
Great, thank you. And I'm sorry, I just realized that we're at time and we're the only thing standing between you and lunch. But I do want to at least offer you the opportunity to ask the question, and then we can crowdsource an answer.
It's actually not a question. I just wanted to mention on the from the last question, in British Columbia, we ran a multi-year initiative. It was about an 8-year initiative called the Rural Education Access to Lawyers Initiative. In another life, I ran that initiative for a number of years. So not that I have any great solutions, but I have lots of experience in that area if anyone wants to talk about this issue of trying to attract rural lawyers from urban centers into rural areas.
Wonderful. All right, thank you. And let's give a round of applause for